Hi, my name is Melanie Murray-Mfume. I'm a private practice attorney. I also work with civil justice and other legal service providers around the state of Maryland, and we're going to talk today about foreclosure mediation. Let's discuss what is foreclosure mediation. Foreclosure mediation is the opportunity for you to sit down with a representative from your lender, with the lender's attorney, with an administrative law judge who is acting as a neutral third party and as a mediator, and with your representatives, your housing counselor and your attorney, should you choose to bring those to mediation. The benefit of participating in foreclosure mediation is that this is going to be the opportunity to sit down with someone from the bank who knows your investor and all of the programs that you might qualify for. By this time, you will have submitted your financial information to the lender, so they will have all of your numbers and will be familiar with your particular situation so that you all can have a meaningful discussion about what might resolve the foreclosure default. Another benefit of requesting foreclosure mediation is that once a mediation date is scheduled, the lender is prohibited from scheduling a foreclosure sale until after mediation concludes. In preparation for foreclosure mediation, you're going to receive a packet from the Office of Administrative Hearings, and it's going to come in a regular sized envelope. In that packet is going to be a white sheet of paper that's going to contain your mediation date, the time, and the location for mediation. You want to pay attention to that location because there are only 12 sites around the state of Maryland, and the county where your property is located may not be the county where your mediation is going to occur. There will be 2 yellow sheets of paper in there. Those pieces of paper are going to contain the document exchange instructions for you and for the lender. There are certain documents that you need to provide, 1 copy to the Office of Administrative Hearings, 1 copy to the attorney for the bank in advance of the mediation. 20 days is what the regulations require. If you're working with the housing counselor and you've already submitted a loss mitigation package to your lender, then you can provide this package to the Office of Administrative Hearings and to the trustee. When you go to mediation, as the instructions will tell you, there are additional documents, updated documents that they want you to bring. Namely, these are pay stubs and bank statements that you have. The lender is also required to provide certain documents to you and to the Office of Administrative Hearings prior to the mediation. You want to make sure that you check this list that's on the yellow sheet of paper and compare that to the list of documents that you actually receive from the lender, and these documents will actually come from the lender's attorney, but you want to make sure that everything that you were supposed to receive that you have actually received. I would highly recommend that you hire an attorney to bring to mediation with you. You are not required to, but it's just guidance. Civil Justice has a low bono mediation program for $500. You can reach out to them. They can pair you up with an attorney that can go to mediation with you. If you are not already working with the housing counselor, I would also very highly recommend that you begin working with a housing counselor. If you contact Maryland Hope at www.mdhope.org, they can provide you with a list of housing counselors that are nonprofit. They're approved by the state of Maryland and the Department of Housing and Urban Development. When you get to mediation, you will be present. The administrative law judge, who will be acting as the mediator, will be present. The attorney for the lender will be present, and the representative from the bank will be on the phone. Let's discuss who you may bring with you to mediation. If you have an attorney or a housing counselor, you may bring them with you. If you have family members or other people who are supporting you, you're also permitted to bring them with you to mediation. If at any point you want to take a time out and step privately with your attorney, with your housing counselor, with your support members, the administrative law judge will permit that. Additionally, if you want to speak privately with the mediator, you're also permitted to do so. When you get to mediation, there is a confidentiality requirement that everybody in the room will be required to sign off on that just says that you can't use any of the statements that have been made in mediation in future litigation, and everybody will be required to sign off on that document. There's also a checklist that the mediator will go over and will walk through each of the individual home retention and liquidation options that may be available for you. Some of the home retention options are going to be a refinance, a reinstatement, which means you're bringing your loan current, a loan modification, a forbearance, things of that nature. Liquidation options are going to include a short sale or deed in lieu, property rent back, things of that nature. And then you will also discuss a deficiency judgment should one, or deficiency balance rather, should one occur, with the understanding that this list is just a master list of all potential options. It doesn't guarantee that anything on this list is something that is necessarily available for you. You want to make sure that, number one, before you go to mediation, any questions or comments or issues that you have about your situation, you want to write them down. Mediation can be a little bit nerve-wracking, and you don't want to miss your opportunity to clarify some questions or comments that you may have because you are nervous. So make sure that you write them down and you bring those with you to mediation. Number two, you want to make sure that you get the representative from the bank on the phone so that they can actually participate in the mediation. Even though the bank is supposed to be a part of the mediation, sometimes the discussion can just be about documents or updated documents that you need to submit. But if you want to talk about the actual programs and the criteria for the programs for your specific lender, you need to make sure to have that bank individual on the phone. If there is an agreement reached at mediation, then the mediator can assist the parties in drafting an agreement. Mediation does not always result in an agreement on that particular day. A lot of times it's just a check-in, it's a discussion about information and programs, or it can potentially be a negotiation. Let's talk about what to expect after mediation if no agreement is reached. There's a 15-day period after mediation by which the lender may not schedule the foreclosure sale. During that same 15-day period, the borrower may file a motion to stay the foreclosure sale with the circuit court. This is a very technical and fact-intensive motion. I would highly advise that the borrower employ competent counsel to assist them in drafting and filing this motion. The borrower is not required to hire an attorney, but it is advisable. If you file a motion, it needs to be filed within 15 days after mediation in order to be timely, or the circuit court may deny your motion. An additional option that may assist you in resolving this situation would be to file a petition for bankruptcy. Again, this is a very technical and procedural matter, and it would be very advisable for you to retain a competent bankruptcy counsel. I would recommend that you hire a bankruptcy attorney that is also familiar with the foreclosure process so that that attorney can assist you in proceeding with applying for a home retention option with your bank. And I want to thank you very much for listening to this presentation today, and I wish you all the best.